First case for argument is WINKLEVOSS v. Steinberg.
Good afternoon. May it please the court, I'm Tony Harwood for the plaintiff appellants. This is an appeal from an order granting a motion to dismiss a defamation claim. The court below committed two errors. First, it erroneously applied the fair report privilege. Second, it erroneously held that the defamatory statements were opinion. The fair reporting of privilege does not apply.
Are your clients public figures?
My clients are not public figures,
Why
Your
not?
Honor. Well, there are two kinds of public figures. There are general purpose and there are specific purpose. They're not general purpose public figures because that's in the extraordinary case for the people who have the most pervasive and powerful influence over society. My clients don't fit that characterization.
Why would they not, however, be limited purpose public figures? They've been shown in movies, they've sort of put themselves in with interviews and magazine articles so that people know who they are. So why would they not be at least limited purpose public figures?
The limited purpose public figure has to be tied to the defamation. It has to be for the purpose, it has to be on the subject that the defamation covered. Here, the subject of the defamation was a small investment, an alleged small investment, in a small privately held company.
So you're restricting the definition of a public figure, limited in general, to what the defamation claim is. That's how I understand what you just said, correct?
For the limited public figure, not for the general, but for the limited. The limited purpose public figure has to have injected himself or herself into the controversy. My clients did not inject themselves into the controversy that is the subject of this dispute. Yes, there are articles about them because they settled a case with Facebook and made a lot of money on it. Yes, there are articles about them because they're big investors in Bitcoin. But this case is not about Bitcoin.
It's about an investment, is it not? And indeed, they've promoted themselves as investors. They've taken affirmative steps to attract public attention to themselves as investors, and including radio channel broadcasts and everything else, and their entrepreneurship. Have they not?
They have promoted themselves as investors, but with this specific investment, they have not sought any publicity.
And you think that we have to parse the limited purpose public figure rule that finally? Is that your position?
That is my position. I think that if we were not to do that, then every investor in the world who ever had the publicity about their investments would be a public figure for any kind of investment they made.
Oh, no. I mean, lots of people get covered in the media because of investments that they make, although not the majority of investors, surely. But your clients have voluntarily participated in conferences and really sought actually to promote themselves, and to also WCF, have they not?
Well, they have, but so does almost every lawyer in this room has participated in a conference about a legal issue. Does that mean that doesn't mean that they're...
That's not exactly what I was describing. I mean, they've promoted themselves. Attorneys go to conferences most often without the desire of having people at the conference learn who they are and appreciate their fame and their record. But I gather your clients were different from that.
Well, I don't think really it's that different. When an attorney goes to a conference and speaks before a room full of people, that attorney is promoting him or herself for that person's knowledge of the law. So does that mean that person is a public figure with respect to the law? I would submit no.
It's asking us to answer a hypothetical. I don't think that's what we have in front of us. But let me ask you this question. In their complaint, don't they kind of somewhat concede that they were somewhat of a media magnet? They allege, unless I'm mistaken, Steinberg knew that in making the defamatory statements about plaintiffs, to the news reporters, they would be published by those reporters in their respective publications. Steinberg was also aware that such publication would cause a chain reaction of republication of the statements in many other news outlets, websites, blogs, and social media, and as a result, millions of readers throughout the world will read Steinberg's defamatory statements about plaintiffs. I mean, they kind of appreciated the fact that they're pretty well known, that this was going to cause an avalanche of publicity about them.
They're well known, but that being well known is not the standard for a general purpose public figure. You have to be more than well known. You have to have pervasive and powerful influence over issues of social importance. They're well known on two topics. They're well known because of their investments in Facebook and their investment in Bitcoin. When we come to the specific subject matter of this defamation, they did not seek any publicity. They did not inject themselves into the public debate. There's nothing in the record to indicate that they did. Now, let me just, since we're on this topic of public figure, that ties into the question of actual malice. So, even assuming that my clients are either general purpose or limited purpose public figures, they have pled actual malice with specificity. So that would not be a basis to dismiss the complaint. They've alleged facts from which it can be inferred that Mr. Steinberg knew his statements were false, made them intentionally to damage my clients, and that's all that's needed to allege the actual malice, even if they were public figures. So I think that we've...
But he just started an action in Delaware, right? I mean, and actually withdrew it once he found another purchaser. Is my memory correct about that?
That was that's the plaintiff in the lower case, the respondent here, Mr. Steinberg, filed an action in Delaware and withdrew it voluntarily.
Right, so I'm just saying, since the Delaware action was discontinued without any determination, I'm not understanding how you alleged actual malice. I'm just not getting that.
Well, the allegation is this. Mr. Steinberg did not have a meritorious claim in Delaware, which is why he withdrew
This
it.
is all rising out of a New York, so that we have a better context. This is all rising out of a New York Post page 6 article that was written about your clients, correct? This defamation lawsuit springs from a page 6 article from the New York Post.
That's what we alleged in the complaint, although we alleged that there were other publications as well, many others, but that's the one that we quoted from.
Yeah, okay,
But I thought
that's the
you
one
were
quoted.
also attacking the things that were said in the Delaware action, right?
The Delaware action is privileged. What's said in the Delaware action, even if false, is privileged. It's the republication of it which is not privileged. It would only be privileged if the fair reporting privilege applies. It doesn't apply here because our complaint alleges that Mr. Steinberg came to our clients and said, if you don't pay me for this obligation, which, by the way, our clients don't owe, which is borne out by the fact that Mr. Steinberg withdrew the case within weeks of filing it.
Well, that's because he got somebody else to buy the shares.
Well, that's what he alleges. But it's our allegations as the plaintiff that have to be taken true and all reasonable inferences from it.
Thank you. At the podium, please.
Good afternoon, Your Honor. May it please the court. My name is Kim Michael. I'm the law firm of Wexler & Cohen on behalf of the defendant respondent Todd Steinberg. I'd like to address something that Mr. Harward just said, which is that many lawyers in this room probably went to conferences. Well, I would bet you that they didn't also attend the Met Gala and Fashion Week and were on the cover of the New York Times fashion section. The Winklevoss twins are not only famous for their investments in Facebook and their investments in Bitcoin. They're famous because they were Olympic rowers. They were famous for their personas, their multiple media appearances, their involvement in celebrity. There are articles that we cite for you in the record on pages 194 to 343 and 450 to 510, over 200 pages that show you that they've appeared as themselves in a cameo on an HBO comedy, a TV commercial for pistachio nuts. They have IMDb pages showing their acting. They appeared on the Today Show to promote their businesses. And Your Honor, you were correct when you said that in fact what they're doing is they are promoting themselves as investors So in addition to the fact that they are general public figures, which, to be honest, I didn't know if I would ever have the opportunity to argue in a case that somebody was a general public figure, but this is the quintessential one. They have been called household names multiple times.
Why do you say that Mr. Harwood is incorrect about his definition of general purpose public figures?
The law, Your Honor.
Just spell it out for us, would you?
Correct, yes. The law makes clear that if you are a household name, that is sufficient to be a general public figure. And here, we've actually cited for you parts of the record where they have been called by the press household names. They have been called an object of cultural wonder, famous, really famous, pop culture icons. Their social media accounts are all verified. What that means is that Facebook and Instagram and Twitter, we may all have accounts on those, but they don't know who we are. Facebook, Twitter, and Instagram, they know who the Winklevoss twins are.
How do you get around him? Okay, assuming that's all there, his malice argument, he's saying that they plead sufficient allegations in the complaint to show that there's been a malice. That they
Correct.
satisfy at least the allegation or the requirement to allege malice.
Well, as this court has said, including in the Brook v. Peconic Bay case that we cited on page 45 and 46 of our brief, conclusory allegations like the appellants are not enough. What they've said, what the facts are here is that there was a term sheet, and that term sheet is in the record. And that term sheet says it constitutes a binding commitment
No,
to buy.
but he's arguing, if I understand him, was that, putting that aside, that your client started the Delaware, this is all arising out of the page 6 article, the page 6 New York Post article,
Correct.
okay? And he's arguing that that Delaware action, you don't get any privilege from that, or you don't get any protection from that, because that was done to, in a sense, strong-arm his clients into settling the case.
Correct.
If that's what he's saying, that's malice. He's saying that all amounts to malice, that there was no bona fides. The bona fides of starting that Delaware action did not exist.
Right, and so that's getting back to the fair reporting privilege.
Right.
And in order to make that argument, what appellants are doing is they're doing two things. One, they're completely misreading the law, Williams and Halcyon Jets, and they're refusing to acknowledge controlling precedent from this court after Halcyon Jets in the form of the Casa de Meadows case, which was decided after Halcyon Jets. This court, all other appellate divisions, and the Court of Appeals have uniformly held that that exception that you're referring to requires an allegation that you have brought an action solely, that's a quote, to defame. And that there's no dispute that they have not alleged that here. In fact, what they've alleged was that the reason the Delaware action was filed was to get the Winklevoss to pay him. That's not malice. And so what they've done is they know that asking this court after all of these decisions, including Casa de Meadows, including Cordell Ree, including Sumaya, and the Court of Appeals affirmance of the Second Department's decision in Bronca v. Mayesh, asking you to expand that exception now isn't going to work. So what they're asking you is...
Oh, in fact, I think, if I recall on the record, the defendant himself didn't go to page 6. They reached out to him to talk to about this article, or interviewed him for the article. He didn't go out and seek them out. At least that's my understanding of the record.
What the article says is that they received, that he commented and the Winklevoss declined to comment. I would believe, that is my interpretation as well, Your Honor. But what is important to understand is that that malice that you're talking about doesn't exist because they haven't alleged what they had to. They've never claimed that the sole purpose of that litigation was as a sham to defame. What they've alleged is he brought that litigation to try to get money out of them. And we can argue the merits of that, but that doesn't satisfy the Williams exception. And the reason for that is important. The public policy behind the Williams exception is that people must be allowed to freely discuss judicial proceedings. And in fact, that statute used to have a malice exception. And in 1930, that malice exception was deleted, which is why the Williams exception is so limited. The concurring Williams opinion noted that the good of all must prevail over the incidental harm to the individual. That is the premise underlying the Williams decision. And appellants have not cited one case to this court, whether it was by this department, the Court of Appeals, or anyone else, in which an allegation that a complaint that may have been brought in part to defame was sufficient to withstand a motion dismiss, because it's simply not.
Thank you.
Thank you.
Picking up where Respondent's Counsel left off with the fair reporting privilege, none of the cases that the appellate divisions have decided have involved a situation where there was a defamation made to extort a payment. What the respondent is asking this court to do is to say, it's bad and you can't defame solely to defame, but if you do two bad things, you defame and you extort, that's okay. That doesn't make any sense.
They were bringing a lawsuit they thought that they were entitled to a payment under the term sheet. Now, the parties may have had different perceptions of that. Of course, it was never decided on the merits because it was withdrawn when somebody else did come along and pay. But how is that really extortion? They wanted initially they wanted a court's determination. Should there have been a payment under the term sheet or not? Was it valid or not? That's a legal issue.
The reason is that this is a motion to dismiss at the pleading stage. Our allegations and all reasonable inferences from them should be taken as true. And our allegation that lawsuit was frivolous, that there were conditions to the contract, and Mr. Steinberg knew it, and that he wasn't ever going to be able to enforce it in court, and he knew it, and that's why he withdrew it. That's our allegation. Their allegation, which is not taken as true, is that he withdrew it because he had another buyer.
That was a discontinuance, right? It was a discontinuance without prejudice.
It was a discontinuance
So
without
I didn't see in the
prejudice.
record in there anything about how the Delaware, and I don't know this, but why, if you're saying that it was used for extortion, if he discontinued without prejudice, that really cuts against the extortion arm because he's no longer seeking any money from you. And the second thing is, I'm not familiar with the procedure rules, but I know in New York here, you sometimes need the other side's okay to do a discontinuance. I don't know if that happened down there.
And
that's not in the record here, so we don't know what happened.
I'm sorry, I was distracted by the light coming on, but if
Still on.
Yes, may I answer the question or should?
Sure.
So, I've lost your question. What was the essence of it?
The essence was the discontinuance of the case in Delaware cuts against the extortion claim because...
So it doesn't, because the extortion was, I'm going to go to the press, and I'm going to be able to do it because it's privileged because I filed this lawsuit. Then he went to the press, he did the damage, he withdrew the lawsuit. That was the timing of it. It was part of his plan. And then he said, I will update the press later, after he didn't get the money.
Thank you. Thank you both. No. No. Thank you. Thank you both. People versus Calvin.